Starting a ministry can be a calling, but navigating the legal landscape can be challenging. Today, we're exploring how to start a ministry without obtaining 501c3 status and what that means for your organization. Churches in the United States have a unique position when it comes to tax law. They are automatically considered tax-exempt organizations, even without applying for 501c3 status. However, this doesn't mean they're free from all legal requirements. To maintain compliance, churches must operate primarily for religious purposes. They must avoid political lobbying and endorsing candidates for public office. Churches that speak out against government-legalized practices considered immoral by their doctrine, such as same-sex marriage or abortion, risk losing their tax-exempt status. While 501c3 status isn't mandatory for churches, not having it can present challenges. Donors may be less confident about the tax deductibility of their contributions. Additionally, handling tax-exempt donations without this status can be complicated. There's a common misunderstanding among clergy about something called 508 church status. This misconception stems from Section 508 OC 1A of the tax code, which exempts churches from applying for 501c3 status. However, this doesn't mean churches can operate outside the law or accept tax-exempt donations without meeting legal requirements. The Internal Revenue Service uses a 14-15-point test to determine if an organization qualifies as a church for tax purposes. Some key points include having a distinct legal entity, a dedicated pastor or board, established doctrines, a regular place of worship, and a consistent congregation. Even without 501c3 status, many states require churches to incorporate. This provides liability protection for members and leaders and enhances credibility with banks, donors, and government agencies. Each state has its own requirements for incorporation. Starting a ministry without 501c3 status can simplify the initial setup, but it comes with challenges. You'll avoid direct IRS oversight on activities and retain more control over religious messaging. However, you may face limited donor trust and potential confusion about compliance with state and federal laws. Churches without 501c3 status that receive tax-exempt donations may not be in compliance with the law. If caught, their tax-exempt status could be revoked retroactively to the date of establishment. This is a more severe consequence than for churches with 501c3 status, whose revocation would only go back to the beginning of the tax year in which non-compliance was discovered. In conclusion, while it's possible to start a ministry without 501c3 status, it's crucial to understand the legal implications and potential challenges. Carefully consider your organization's needs, consult with legal professionals, and ensure you're complying with all relevant state and federal laws. Remember, the goal is to focus on your ministry's mission while operating within the bounds of the law.